Power of attorney. Do I need to see the actual power of attorney document? Whose name goes in the certificate? How does the attorney in fact sign this? Is this power of attorney even still valid? These are some of the questions that a lot of notaries face when it comes to a power of attorney. We've got the answers for you. Stick around. Two terms that show up on every power of attorney document. The principal. The principal is the person granted the authority, the one who signed the power of attorney document, giving someone else permission to act on their behalf. The attorney in fact, also called the agent, is the person granted that authority. And despite the name, they don't have to be a licensed attorney. It can be a family member, a friend, anyone the principal has authorized. The principal grants the power. The attorney in fact uses it. Your job is to notarize correctly for whoever is actually in front of you. Here's what's worth knowing up front. Power of attorney notarizations have more state-to-state variation than most other notarial acts. Your state's rules are what you need to apply on your end, and they always take priority. The most common situation you'll encounter, the power of attorney document already exists and has been fully executed. Now, the attorney in fact is using the authority to sign a different document on the principal's behalf. To be clear, you're not notarizing the power of attorney itself here. You're notarizing a separate document that the attorney in fact is signing under the authority that the power of attorney grants them. Verify the identity of the attorney in fact, not the principal. They're the signer. Only their ID is required. Standard identity check. Photo, physical description, signature, and expiration date. Step 2. Confirm the attorney in fact has the authority to sign. Some states require the attorney in fact to present the original power of attorney document as a written proof of their authority. If you're in one of those states, review the document carefully. If your state doesn't require written proof, the NNA recommends asking the attorney in fact to formally state out loud in your presence that they have the authority to sign on the principal's behalf. Your state rules tell you which method applies. Step 3. The attorney in fact signs, and they sign with two names, their own name and the principal's. Two formats are common. Jane Smith, attorney in fact for John Smith, or John Smith by Jane Smith, attorney in fact. Jane is the only person who signed. Jane is the only person in front of you. Step 4, the notarial certificate. You write the attorney in fact's name in the certificate, not the principal's. Jane personally appeared before you. John didn't. The certificate reflects who was actually there. If your state doesn't have specific attorney in fact certificate wording, the standard acknowledgement works. Just write in the attorney in fact's name. And step 5, your journal. The attorney in fact signs the journal with their own name. And note how you confirmed their authority. Whether they presented the power of attorney document or made a verbal declaration, that's your record. That's the job done right. One more thing, and it applies to any time a jurat is involved. If an attorney in fact requests a jurat, they can only swear in their own name, not the principal's. The oath is personal. It can't be made on someone else's behalf. Jane can swear that she, Jane Smith, attests to the contents of the document. She cannot swear on John's behalf. That line doesn't move. Two names on the signature line, one person in the room. You know what to do. Know who's in front of you, know what they're authorized to do, and notarize for the person who actually showed up.